Hello guys, and welcome to another episode of my lecture. On today's episode, we will be talking about the Lady Gwendolyn's case. In my previous video, I told you about the case of Leonard, I told you about the Meridian case, but today would be the Lady Gwendolyn. And just like we have done in the past, that is in Leonard and Meridian's case, the fact to be showing on the screen, we are going to discuss the issues as well as how the judges had answered the question in each of these cases. We are going to do the same thing with the Lady Gwendolyn case, as well as the next case to come, which is going to be Tesco Supermarket Limited versus Natres, and also the case of Ehrlich versus Lifa. So let's start with the fact of the case. The fact of the case, the Lady Gwendolyn. The plaintiff owned the Lady Gwendolyn, which collided with and sank the defendant's vessel. The collision occurred in very thick fog, fitted with radar going at full speed. The radar was on, but not continuously manned by the master, who admitted in evidence that he habitually navigated in fog at excessive speed without instruction as to the use or misuse of radar. Although all the ship log were regularly submitted to the marine superintendent, he had failed to observe the master's practice of going at excessive speed in fog, even when apparent from simple examination of engine records. Neither assistant managing director nor traffic manager showed interest in navigational matters and were content to leave all the matters to the marine superintendent. Consequently, the master's practice of excessive speed in fog was never detected, and it was this practice that made there to be a collision between the plaintiff's own vessel, called the Lady Gwendolyn, and then the defendant's vessel. Now, the plaintiff admitted liability for collision, but claimed to limit it under section 503. What they were saying in that particular case is that yes, we agree that we collided with the defendant's ship, but do not forget that under section 503 of the Merchant and Shipping Act, which was the same thing that was relied upon in the Leonard's case, they were saying that they are not, as a company, supposed to be liable, because that particular section says that where the company does not know of the faults, where the company has no knowledge of the fault, the company would not be liable. Now they are saying that the person who drove the ship cannot be said to be the company. He cannot be said to be acting for the company. That is their argument. Therefore, if his act cannot be said to be the act of the company, his knowledge on going at excessive speed would not be said to be the knowledge of the company, so much so as to attract statutory liability. Do you understand? So basically, that was their argument in the Lady Gwendolyn's case. The trial judge held that the company, they were at fault. On appeal, they were held guilty of failing to perform their duty, and their breach had thus contributed to the collision. Winter J held that where a company has entrusted the management of its ship to a traffic department, that is the effective head, the traffic manager therefore should be regarded as the alter ego of the company for the purpose of its shipping business. So therefore, his act and omission can be attributed to the company as its act and omission. Do you understand? Now I want you to get the perspective of Winter J before we proceed. Winter J was basically telling us that when it comes to certain specific things in a company, where you have put an agent in charge of those things, the most important question that we should then ask is that agent under any supervision? If the agent is not under any supervision from any higher authority in that company, then the act of that agent can be said to be the act of the company. If we apply this principle in the Meridian case, you would see that in the Meridian case, Mr. Ku and Mr. NG was the portfolio officer, Mr. Ku was the investment officer. The investment officer, his duty is to make investment. He made investment with no superior authority in the absence of any superior authority over Mr. Koo, those investments that he made can be said to be the investment of the company. Do you understand? Now, if you look at this case, I want to read again what I read before. He said, where a company has entrusted the management of its ship to a traffic department, the effective here there being the traffic manager, the traffic manager should be regarded as the alter ego for the purpose of such shipping business. In an investment company or in any other type of company where you have delegated from the board to a particular person with no supervisor, and then he is given the leeway, he is given the freedom to do certain things without necessarily having to submit himself or submit a report to an higher authority, that person's act should be the act of the company. Continuing with what Winter J said, Winter J held that neither the Court of Appeal nor the House of Lords in Leonard Carring's case said that a person whose actual fault to be the company's actual fault must necessarily be a director. That is the most fantastic statement that I like. In this case, they pointed it out. You don't need to be a director before your act would be termed the act of the company. Therefore, the liability that you incur would be the liability of the company. You necessarily don't need to be a director. Do you understand? Then you move on. The head of the traffic department can also be somebody whose action is the very action of the company itself. Here, the head was also the registered ship's manager, thus his fault to be sufficient to constitute the actual fault of the company. I love this case so much because it's a very interesting and straightforward case. Here you have a person that was moving at excessive speed all the time, and then there is no supervisor over him as to question his excessive speed, even though it can be seen in the record that this guy is always going at a certain speed. Now, there was a collision between his ship and the defendant's ship, and then the company is then relying on section 503 of the Merchant and Shipping Act, saying that where the company doesn't have actual knowledge of what is going on, the company cannot be at fault. Now the question is, the traffic manager in this case, can his knowledge be termed to be the knowledge of the company, so much so that his fault will be the fault of the company? Now, in the judgment of Winter J, he said that yes, in this case you have nobody that is supervising this guy, same way you have in the Meridian's case where there was no supervision. Where there is no supervision over a person, then that person, his act would most likely be the act of the company. More so where the primary rules of attribution has allowed the person to do such act, followed by the general rules of attribution of agency, which has also allowed the person to do such act. When the person does such an act without express supervision from someone, then that act would be the act of the company. That is basically what was held in the Lady Gwendolyn's case. And lastly, to note is that Winter J pointed out in the Lady Gwendolyn's case, the person whose fault is to be the fault of the company doesn't necessarily need to be a director. Do you understand? You just need to have been delegated duties by the board of directors or managing director without supervision. That is the formula that can be coined in this series of cases. So now we are going to the next case of Tesco Supermarket Limited versus Natres. See you in my next class.